Good morning, everyone. We have one case to hear this morning, the Sheffield versus the Detroit City Clerk and the Detroit Charter Revision Commission. This is a mini oral argument on the application, which means each side has 15 minutes. Mr. Phelps, if you want to reserve some time, you'll do your best with that. And then I understand you all will be sharing time, and you can explain to me who's going first and how much and what you're doing once you start talking. How about that? And with that, we can begin. Mr. Phelps.
Thank you, Your Honor, and may it please the Court, Aaron Phelps on behalf of the Detroit Charter Revision Commission. I will attempt to reserve 3 minutes for rebuttal, and I understand I need to keep track of that time. I'm going to start today with Article 7, Section 22 of our Constitution, and it provides that under general laws, the electors of each city and village shall have the power and authority to frame, adopt, and amend its charter. That is where the power and authority resides with the people. And the people of the city of Detroit voted in 2018 to do just that, to revise their charter. Then they voted again to elect 9 commissioners who would undertake that task. In the nearly 3 years since that time, they have spent thousands of hours soliciting input, drafting charter language, and engaging with the community in an effort to present them with a proposed charter revision. They have now done that, and a third vote is now literally underway to be concluded on August 3, an up or down vote on whether the people of Detroit want to revise their charter in the manner that has been proposed. And before the court now is whether all of that has been for nothing, because the lower courts have said that it was. Under those rulings, the power and authority resides with the governor and the governor alone. She, for any reason or no reason at all, can stop a charter revision from going to the people. She may substitute her policy judgments for those of the people. She may substitute her personal values for those of the residents of any city or village in this state. And, as she has done here, she may substitute her legal opinions for the opinions of the Charter Commission and thereby prevent any judicial review of those opinions. The first question that was posed by this court for this argument is whether a proposed revision of a city charter can be submitted absent the governor's approval, and the answer is yes. The Home Rule Cities Act, which implements the constitutional right of the people to establish their own charters and amend and revise their charters, contains multiple provisions that enable local people, local government. It's all intensely focused on individuals within cities and villages and establishes processes by which they revise and amend their charter. Not the legislature, not the executive branch, not the governor, the people in those communities. Nothing in the act requires the governor's signature before the revision may be submitted for election, a fact observed by the Attorney General herself in her review of the very charter that's at issue in this case. That review from the Attorney General was adopted by the governor as her review of the charter and submitted to the Charter Commission earlier this year. And in fact, nothing in the Home Rule Cities Act, including Section 22, requires that charter revisions be submitted to the governor for her review before they can be voted on. And this is a critical fact and a critical portion of the statute, which frankly was not addressed by the lower courts. Section 22 draws a distinction between revisions on one hand and amendments, 2 types of amendments, on the other. And it very clearly says that amendments must be transmitted to the governor, quote, before its submission to the electors, close quote. It then goes on to say, and every charter before the final adjournment of the commission. They are broken into 2 separate categories in the first sentence of Section 22. The revisions never are attached to be required to be submitted before a vote can take place. This court asked about the amendment history, 1909, 1913, and what impact, if any, it has to this analysis. This very issue is apparent when you analyze those two statutes. 1909 statute has the same introductory language, amendments, revisions, treated separately. One must be transmitted to the governor before it can be voted on. Revisions need not be. What's inconsistent, internally inconsistent, in the 1909 statute is when you read to the end of it, it states that if the governor objects, then you need a 2/3 vote to override that objection, then it may proceed to an election. Well, now that really doesn't make any sense, because if you've just said revisions don't need to go to the governor before election, then why would you have a 2/3 override before it can go to a vote? That's corrected in the 1913 statute. That inconsistency is resolved and harmonized. They leave the same language, they keep them separate. Revisions are not required to go to the governor before a vote. Then when they talk about the 2/3 override, it's now limited to the only thing that's actually tied to the governor's review as a prerequisite to voting in the first place. So a 2/3 vote for a legislative amendment, and in the case of initiatory amendments, they need not have any further vote at all. But those two things are the only thing in the first clause of the statute that are even required to be provided to her as a condition of election.
Why would the legislature want the revision to be sent to the governor after the election?
As a record for her review, I don't know why they would. It's before final adjournment.
And they would require the governor to review it, and if she approves it, to sign it, and if not, to return it to the commission with objections, all after the election. That would be completely meaningless work, right? It would have no impact on the charter, whether it would become the charter, whether it would be adopted. It would just be for show or to record for the annals of history in case things went wrong later. The governor could say, "I told you so," or what? Come up with a reason why you think the legislature would set up a process like the one that you just described.
They did set up a process where they have said you do not need to provide the charter until final adjournment of the commission. I can speculate that that's a formality, that is perhaps a tradition in this state that dates back to long before we even had the 1909 and 1913 statutes, where the governor and the legislature did play a much different role than they do today in establishing charters. It provides a record for the governor, its formal notice, which maybe seemed more relevant back in 1909 and 1913 in a totally different age than where we are now. I can imagine
back
that.
in those days, that language was a lot like the language in the Constitution that described the governor's veto power over legislation, right? If he approve it, he shall sign it. If not, he shall return it with his objections to the House in which it originated, et cetera, et cetera. And then there's a 2/3 override provision, of course, for legislation. Why should we interpret this language to mean something much different than that?
Two reasons. I think we have to give meaning to what is actually in the statute. And there is a clear distinction that's drawn. One is before, they could have said amendments and revisions before they go to the electors must be transmitted to the governor. They broke them apart and made it clear that in the case of revisions, it's before final adjournment, which we all understand can be after an election. In fact, the whole statutory scheme contemplates there might be as many as 3 elections over these revisions. So that is, we have to give meaning to what is there.
Does final adjournment have to be after the election?
It wouldn't have to be. I think they could finally adjourn whenever they want. They have to adjourn no later than 3 years after they start, which is about August 6th, I believe, in the case of Detroit Charter Revision Commission. The second, Your Honor, reason why it should be interpreted this way is because it's really mandated by the Constitution. And at the end, we spend a lot of time and effort, rightfully, trying to understand what this 100-year-old statute means. Why did they use these words they did? Why were the amendments changed? But something else happened 50 years after this statute was passed. And that's the 1963 Constitution. And that Constitution doubled down on home rule. It states clearly the power and authority resides with the people, doesn't say the governor, the legislature at all. The people have 100% of the power and authority to frame, amend, and adopt their charter.
This statute's been in place for over 100 years, which means I think that most Michigan cities that have charters have been organized pursuant to this statute and pursuant to this procedure. So what would that mean if we were to agree with you? What would it mean, that all of those charters are illegitimate or maybe called into question if they allowed the governor to have influence on the terms of those charters?
No, there is absolutely no prohibition on the governor having influence, giving her opinion. She's done so in this case. This ruling will have nothing to do, no effect at all on any current or existing charter. The question before this court is whether this charter may go to the voters, continue to be voted on by the people of Detroit. Is the governor's signature a prerequisite? If she had it, if they had it, they had it, it wouldn't even be an issue. So it's certainly only going to be relevant in cases where the governor objects to the charter.
And just going back to the 1909 statute, that statute had a provision for a charter commission to override I'm calling it the governor's veto because that's the term used in the margin of the statute, at least the public act that I have in front of me. But there is a provision for a charter commission to override, just like a local legislative body, like a city council that proposes an amendment, to override the governor's veto or objections. What should we make of the fact that that statute was amended a couple of years after that to eliminate the ability of a charter commission to override the governor's veto by a 2/3 margin? What should we make of that?
We should make of it that they recognized that they were not requiring charter revisions to be submitted before they could go stand for election. So it didn't make any sense for there to be a 2/3 override of something that's not required in the first place. If you're not required to send the charter revision until any time before final adjournment, not necessarily before an election, then there may not necessarily be objections and there's nothing to fix there. And that's really where we believe the error happened below.
And then in its application, the statute, according to your theory, has been misinterpreted and misapplied by almost every jurisdiction that submitted charter revisions to the governor in advance of the election? Because they didn't have to do that till after or until they adjourned?
Every charter amendment under the statute needs to be
No, I know, revisions.
Every revisions certainly can be anytime. They're required to be before final adjournment. They're not required to be as a condition of voting in an election, having that revision voted on. That is not a requirement of this statute. And so that explains why there's no mention of a 2/3 override, nor...
My point is sort of the practical point. We have 100 years of history leading up to this process in which your client apparently followed what appears to be the routine that people have followed for the last 100 years, which is they submit revisions to the governor to receive the governor's input well in advance of the election. In fact, your client appears to have done so, or at least they thought they did so, in time to even submit a revised charter to the governor, or additional revisions, or further revisions to the governor. But so that your theory is inconsistent with the way your own client proceeded here. Is that not true?
It is not. There's no prohibition. It's not inconsistent to send something to the governor. It's required to be sent at some point, whether they sent it, last year, this year, last month, anytime before August 6th is within the statutory time period. So they have done nothing inconsistent. And I only have a minute left, so but I do want to leave this thought, to make sure I say it, is the 1963 Constitution adopted Section 34, which requires, in almost foreseeing situations like this, anytime there is an issue of interpretation involving a constitution or law that relates to a city, it is to be liberally construed in favor of the city. And perhaps this 100-year-old statute isn't entirely clear. The Constitution tells us what we do. we construe it in favor of the city. We construe it in favor of the Charter Revision Commission and the people of the city. We don't construe it in favor of the governor and give her a right that is not set forth expressly in the statute, and which would be totally inconsistent with the entire idea of home rule and would totally supplant the Article 7, Section 22, which provides the power to the people to set their charter and not otherwise. Thank you.
Good morning, and may it please the court. My name is Jason Hanselman. I'm appearing on behalf of the Lewis appellees, although Mr. Pauwels and I are going to at least attempt to split our time equally this morning, and we'll be sure to try to monitor our own time. I'll be addressing the court's first question regarding the requirement of Section 22 of the Home Rule City Act that the governor approve the charter revisions before they're submitted to the ballot. And Mr. Pauwels will address the legislative history and explain why the legislative history supports that conclusion. There are 4 reasons it's clear the governor's approval is necessary here. First of all, Section 22's plain language requires charter revisions to be submitted to the governor, and the governor has 2 options: approve it or return it to the city. The Charter Commission's actions, as we just heard, show that it agreed that those are the only 2 paths up until changing its position for this litigation. Third, the second 2 sentences in Section 22 will be completely nugatory if the governor's approval isn't mandatory, because all proposed revisions would just proceed directly to the ballot with or without the governor's approval. And fourth, comparing Section 22 with the parallel provisions for villages and counties makes clear that the legislature knew how to authorize an override of the governor's veto of a revision, but chose to discontinue that practice for cities. This statute is designed to protect voters from precisely the type of proposal that's full of illegal and misleading provisions that the governor and attorney general rejected the current proposal for. The Charter Commission's now arguing that Section 22 is silent regarding what happens if the governor doesn't approve it, but that's not true. Section 22 says exactly what will happen if the governor doesn't approve a charter revision, and that's to return it for the city to fix the problems. It's not ambiguous, it's simple. And the process actually makes a lot of sense because these home rule cities are creatures of statute. The governor and the AG review proposed revisions to see if there's a problem, as there are with the current proposal. They then return it to the commission to fix those problems. The commission then makes the needed changes, like it did here, and can resubmit it to the governor for approval.
Council, good morning. I always like to keep things simple, and I guess my question to you is, why shouldn't the default be to allow for people to have the opportunity and the right to vote?
Well, I think precisely for what I just mentioned in my introduction, this is a process that's designed specifically to protect the people. There are multiple layers in that process.
It protects the people by not letting them determine or decide their own destiny?
Well, I think this is a great example of why it's important. As we talked about in our briefing, the Charter Commission missed the deadline for filing, so the people didn't know what was going to be on the ballot. They've suggested both publicly and in pleadings that they can change it whenever they want to up until Election Day. They then publish different versions on their website, so there's 2 different versions, one on the Twitter feed, one on their public website. The Twitter feed refers back to the website. So it's precisely to make sure that there aren't these kind of confusions. What they did was went back and fixed the problems, but then never actually updated the published.
But it seems a little paternal, doesn't it? I mean, the idea is if I live in a city, then I'm subject to this, but if I live in a village or a township, I'm not. It seems like it's very focused on cities.
Well, and actually, the Villages Act and the Counties Act have the exact same process. Those do allow for an override,
Right.
But for whatever reason, in the legislature's wisdom, they decided to eliminate that. And Mr. Pauwels will speak a little
But
bit.
if I'm not happy with what the DCRC did, I can vote accordingly, right? Why do I need to be told that, you know, your argument was, well, there's all this misleading issues and these types of things, but if I live in Detroit, I can surmise that for myself, right, and then vote accordingly?
Well, that's certainly true, but we have all sorts of ballot requirements. Most of them are designed to protect and educate voters and inform them before they go to the polls. This is one of those types of ballot
But that's not what you're arguing. You're arguing it shouldn't be on the ballot.
That's correct. It should not be on the ballot, according to the legislature's drafting in 117.22.
But you can understand how people would be frustrated by that, right?
I absolutely understand that.
Okay.
The charter, as I mentioned, the Charter Commission's argument is silent. It's not. The process here is very clear because these are creatures of statutes, as I mentioned. The Commission failed to present any examples, as Justice Viviano mentioned, of a city submitting a charter for the ballot after or without the governor's approval. The only example we could find of a city attempting to proceed without the governor's approval was addressed in a March 24th, 1942 AG opinion, cited in our supplemental brief, that opines that a charter amendment was ineffective because the governor had not approved it, quote, as required by Section 22 of the Home Rule City Act. This is also a situation where I think the Commission's actions speak louder than words. When last amended the Detroit Charter in 2012, just 9 years ago, the Charter Commission obtained the governor's approval, then touted in its publications that it had the governor's approval. It was cleared for the ballot precisely because it had the governor's approval. The Commission set out to follow that same process here. The Commission's original flight plan, as they called it, called for this to be submitted to the governor by November 2020 in order to give them plenty of time to go back and fix any problems the governor identified and resubmit it for approval. The Commission missed that internal deadline, didn't get it to the governor until March 5th, then went to the governor and asked twice in the transmittal letter to please turn this around in 60 days, which aligns directly with the time frame for certification of the ballot. If the Commission really thought a proposal could appear on the ballot without the governor's approval, with or without the governor's approval, why ask for expedited review? Why go back and fix it and resubmit it to the governor?
Counsel, how would you address their argument that says that they have, regardless of whether they're required to obtain the approval prior to putting it on the ballot, there is a point to asking the governor and getting her input, exactly perhaps for the reasons you suggest, that then you are able to, in your public campaign, encouraging voters to pass it, you are able to say, look at, the governor has looked at this, she approved it, she supports it. I mean, so there is a point, is there not, to submitting it to the governor regardless of whether or not you have to?
No, and I think that's what both the lower courts address, and one called it an empty and useless gesture, and another called it a gratuitous support. I do not agree that would be a useful use of the governor's time. My understanding is the governor has a person on the staff that primarily reviews city charters, and that seems very wasteful if it was just an advisory type opinion. I think that'll also be belied by the legislative history when you see that the original legislation went from using the phrase recommendation to the current provision that now says approval. I think that word approval has some meaning to it. I'd just like to turn briefly to the second two sentences of Section 22, which are important because they explain what happens after a proposed revision is returned without the governor's approval. The second part of the second sentence creates an override provision if the governor doesn't approve an amendment. But that would just be mere surplusage if the Charter Commission is correct that everything just proceeds to the ballot with or without approval. And the third sentence makes it even more clear because it expressly provides an initiative petition to be placed on the ballot even if the governor doesn't approve it. Looks like I'm running out of time here, so I will just jump ahead. So there's a clear process. This is designed to protect the voters. The governor approves it, it goes on the ballot. If not, she returns it for the corrections to be made.
But Counsel, you see my concern, right? And I understand your argument, but you see my concern. You're arguing it's designed to protect the voters by saying that they shouldn't be able to vote.
I do understand your concern.
You understand why I would have this question to you?
Yes, I do.
Thank you.
Thank you.
Good morning. Andrew Pauwels on behalf of Appellees Horace Sheffield III and Rodrick Harbin, and I will be primarily addressing the historical context of Section 22. And Counsel for Appellants ignores an important context of this history, and that's a context and a history of compromise, a compromise between Home Rule, which was an entirely new concept at the time of the 1908 Constitution and the Home Rule City Act, and state oversight of every aspect of municipal government, which was the practice at the time. And this history reveals and confirms the plain text interpretation that Mr. Hanselman just argued. That is, one, the act provides for a governor's veto, not merely an advisory role, in the context of revisions of city charters. And two, the act provides no mechanism to override that veto in that context. So prior to 1908, city charters were enacted by the state legislature and subject to the governor's veto. In the late 1800s, in Michigan and elsewhere, there was a growing backlash to this special legislation, and so Michigan adopted, like many states, home rule. And the 1908 Constitution expressly framed this home rule as a compromise. Article 8, Section 21 stated that cities had the right to frame, adopt, and amend a charter subject to the Constitution and general laws of the state. And the language at the time confirmed that this was a compromise, not an absolute right. The framers noted, and this was in the Journal of the Constitutional Convention, that the transfer of power from the state to cities, quote, necessitated the imposition of certain checks and prohibitions. And this court in Street v. Vermillia, 268 Mich. 1, recognized this compromise, stating, the Constitutional Convention compromised by giving cities the right to frame, adopt, and amend their charters, subject, however, to certain broad general restrictions and limitations fixed by the legislature in the so-called Home
Counsel,
Rule
if I
Act.
could just jump in, I appreciate all that history and recognize sort of the journey that the statute took. What I'm wondering is that compromise, I mean, do we really think the parties intended that the governor could have an unfettered veto over cities for any reason whatsoever?
Your Honor, respectfully, I'm not sure the veto is unfettered in that the governor is subject to the checks of the electoral process and that the people are, free to contest the governor, to challenge the governor in the next election. There are recall processes, and simply the nature and scope of the governor's power here is also not at issue. The appellants don't contest that the governor's power was exercised here in an unfettered manner or that any specific objections made by the governor were improper. That's not the issue before the court. The issue is whether the governor has the right to veto, and the governor does according to the statute and the historical context.
All right, thank you.
Counsel, can I ask, I understand the position that you've taken regarding the history of the statute. And let's assume that if we were just looking at the statute in isolation, and the history could go either way, maybe you even have the better argument that the removal of the override suggests by implication that it can't be overridden in the new statute. But we're not looking at the statute in isolation. We're looking at it against the backdrop of the constitutional provisions that say that the ability to draft and amend and revise the charter resides with the electors. And we have said that the home rule cities have not only those powers that are specifically granted, but they must exercise or may exercise all the powers not expressly denied. So against the backdrop of the Constitution that says that power resides with the electors, and the legislature has not specifically said that the governor gets a veto, how are we supposed to square? I think it's our obligation, right, to construe the statute so as to be consistent and not contradict the Constitution. So by negative implication, you're asking us to say that the governor does have a veto and that the Constitution doesn't keep that power with the electors.
I think there's two questions built in there, and I'll answer them both in turn. First, regarding the Constitution, the 1963 Constitution, while I think it modified the compromise between home rule and a certain degree of state oversight or acting in accordance with state law, it didn't abandon that compromise. It expressly preserved it. The first phrase of Section 22 is under the general laws. And in fact, in the address to the people by the Constitutional Convention, the convention stated the new language is a more positive statement of municipal powers subject to state constitution and law. So the compromise remained in place. And then regarding the second aspect of that question, I'm sorry, I've lost my train of thought here. The Constitution didn't abandon that compromise, and we're not asking the court to abandon its case law in cases like Associated Builders. This isn't a matter of the substantive scope of municipal authority. This is a procedural check on a city government, and it is the right is expressly prohibited in the statute, and that's Mr. Hanselman's argument regarding the plain text.
Is the governor's veto expressly provided in the statute, or is it by implication no mention of what happens if the governor disapproves?
It is expressly provided because the language used to approve it and sign it and return it is the language of veto that has been used by the state legislature in many contexts, the state constitution, the legislative veto, and so that key language there is an express provision. I understand I'm out of time unless anyone has any other questions. I'll sit down.
Thank you, counsel. I think you reserved 13 seconds, but if anybody has any questions.
I did, and I've been thinking, how will I use that? It is to say this: the interpretation of Section 22 of the statute that is adopted by the Court of Appeals cannot be squared with a liberally construed, under Section 34 of our Constitution, Section 22 of our Constitution. The power is with the people, not with the governor. We ask that it be overturned. Thank you.
Thank you, counsel. Case will be submitted.